All right, sir, are you Avion Johnson? And this is 24 DCCR 2044. Mr. Johnson was previously in court, entered a plea of guilty to the offense of arson, intending to damage a habitation or place of worship. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor. Yeah.
Any additions or corrections?
So, no corrections. There was an issue. Ms. Martino and I have spoken about this. On page 2, very top where it says constitutional issue, it looks like there's an outstanding bill, if you will, to repair in the amount of $150,000, but I don't know if that's the actual case.
I would agree, directly from the Lord.
Sure.
But that figure came from the fire department, not from the apartment complex.
Okay.
The apartment complex may be under governmental control, and that may have some secure issue. With respect to what Martin Arnold said, and he does not know him very well, actually. He understands the movement I was in with respect to the plan. Court no, engaged out with status, cognitive ability, just he would like me to figure out into where that constitution is owed to the beginning. Obviously, it's a way substantial amount for Mr. John. I am concerned about his behavior.
Well, I'm concerned about his behavior, but I'm just as concerned about the fact that he denied the offer.
Yeah.
So, if you didn't do it, then you shouldn't have pled guilty. And so that's what a jury's for, to come in and decide if you are guilty or not. This says, at least what they put in here, that you said that there was a bottle of lighter fluid on the floor, that she flicked a cigarette and the fire just started, which is different than what, it's obviously not arson, that's an accident. And so we've got to get past that before we do anything else. So either you did what they charged you with, which is starting it in anger or whatever else was going on, and or not. So again, that sounds like an accident, not arson. Because here's the thing. I mean, a 5-year deferred probation is a great deal. I mean, you don't have, I mean, not say that. And a revocation. Anyway, if you violate your probation later and you're back in here on a motion to revoke, I mean, it's a first, right? I mean, you're looking at 5 to 99. And if I say, you know what, I think you deserve 25 years in prison, you can't say, well, I didn't really do it back then. I shouldn't have pled guilty. So you're stuck. So either you did it or you didn't do it. You know, when you were here before, you were standing in front, you stood in front of the clerk, you took an oath, you said, you're going to tell the truth. And so telling the truth is either accepting responsibility if you did it, or saying it was an accident. And if it was an accident, it's an accident. Okay, all that's great. Did you do all of that because you're guilty of the offense? So I guess what we need to do at that point, then I don't mind. The only problem is I need to have that restitution before sentencing. But I don't want him, if he's getting a deferred, he didn't need to be sitting in jail.
An idea might be land use to order not to exceed that amount.
Sure.
Drop it.
Yeah, that's probably the easier way to go ahead and get it sentenced so you can get out. Obviously, I wouldn't expect that it would be anywhere near that. I mean, that would.
Did you understand my?
Absolutely, I do. Yeah, and then if there's an issue when the restitution amount, if any, comes out, and we need to have some type of hearing on that, then we can still do that, even though he's sentenced if I do a not to exceed amount.
Yes.
So do you understand, Mr. John? So what I'm going to do is go ahead and give you the probation today. I'm going to order restitution not to exceed $150,000. No one expects, I don't think, for it to be that, or maybe who knows what. Maybe not anything, maybe much lower than that, depending on insurance and whatever else. If there's an issue with that, we can handle it later, but that way we can get you sentenced today and you can go ahead and be released. Do you understand? Now, if there is restitution, and you will be required to pay it on that probation, so it's really important that if there is any order, that you start making payments on whatever it is every single month, even if it's just a little bit, to show me that you're making.
Despite the serious charge, the defendant is being given deferred probation instead of prison. But don't mistake that for an easy outcome. Deferred probation is one of the biggest second chances a court can give, and one violation could erase that opportunity and expose the defendant to a sentence ranging from 5 years to life. That's an incredible amount riding on one decision.
Okay? So what I'm going to do is find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the attorney. Defer all proceedings for a period of 5 years. There will not be a fine in your case. There will be restitution ordered in the amount of not to exceed $150,000. Now, I have a note here that if I accept this agreement, there might be something else I do because of your guilt. You know, you were just in a fight in July out there. June, talking disrespectfully to, I'm not real sure what's going on in the jail to make any of you that are sitting in jail thinking correctional officers are going to somehow have anything to do with you when you get out of jail. I mean, really? You think that's where you're going to meet your next girlfriend? Then you shouldn't be talking to them like that, right? I mean, you threatened one male officer that you were going to beat his ass. I don't know. You probably shouldn't. How old are you? You're too old to be acting like this. This is the kind of stuff I'm getting on the little young punks out there. You know who I'm talking about. All of them that are out there acting like heathens. That shouldn't be. You're not doing near as much as all them, but I shouldn't be having this on somebody that's in parties. I mean, you've already been on probation and know what it takes to be on probation and didn't do it. So I hope that by going forward today, you understand, just like I said, if you follow all of the rules of this probation, great opportunity, right? You don't have this conviction on your record, get out, you live it like the rest of us. If you violate any condition of probation, you're brought back into court, you become a convicted felon on this case, and I have the whole range of punishment, which is 5 to 99 or life. And I'm going to look back at that time and see that I gave you an opportunity on probation when you just revoked the probation 2 years ago. And so it's probably not going to be some little amount of prison and you just get to go on your way. It's going to be, you need to start learning from your mistakes kind of thing, right? Makes sense? Right. So I'm going to hand you the trial court certification that shows this was an agreement that I followed, so you've waived your right to appeal. Probation will give you some information today before you leave. Make sure as soon as you get out, first thing you do is do probation, okay? All right, good luck. Thank you. If you want to go to trial and not accept a plea agreement, then listen to your attorney and do what he's telling you to do.
You know, right now, I'm still
Yeah.
working. Yes. There's like 5 weeks straight. You go about these different places all they all on night.
All right. Stop talking. This is clause numbers 24 DCCR 1500, 24 DCCR 1614, 1615, 25 DCCR 0436, and you're Traylon Hill. And Mr. Hill's charged, go through this, in clause number first, 1500 with obstruction or retaliation. Do not do that again. Who's in here for him? All right. Ma'am, can you move over to that back corner so that he cannot see you and be distracted? Thank you for being here. Mr. Hill, you just don't know how to behave, do you? Saying you're sorry doesn't matter. This is nonsense. Since we were here last time, I don't even know how many more pages of the nonsense that you've been doing in our jail. Okay.
You're not gonna try my I'm getting the microphone. I make you encourage you to make sure I actually call the phone, help the time. You know, the game to play, right?
Yeah.
The orders, you know, I'm just trying to do it.
Okay.
I got the job, got it home. Extra long, I need to be working, you know, I think my mom is on the roof housing. You know what I'm saying? I'm actually trying to take it into the business, my you know.
Yeah.
My business,
Well, it doesn't look like you are.
looking at see he's a little.
So one of the time you're running back and forth, playing like a little kid in the day room. Who made you do that? Are you allowed to do that in the jail? Okay, so are you allowed to do it in the other room? Are you allowed to do that? You are? Uh-huh. So are you, who made you dash the floor with water? Who made you dash the floor with water?
I'm not the only one.
Well, this is my question.
No one did.
No, but you did it on your own, right? Nobody's going to stop talking when I'm talking. I'm going to ask you some yes or no questions. So nobody's making you do those things, right? Nobody bullied you into dashing water, right? Yes or no? Okay, hold on a second. What about why do you continue to make comments to the female officers out there? Why do you think that's okay after you've been told not to do that?
All day long, I still hear about
Because you're a lover boy. So you understand that part of all of this trouble and you not being able to get your cases worked out is because you can't follow that rule. Did somebody bully you into being that way to those officers?
Man, you know what I'm saying?
Oh, yeah?
It's just inmates, you know, I live to be around.
Okay.
The courtroom just took another turn. The prosecutor reveals there may be new criminal charges coming based on the defendant's conduct in jail. That's a major development because a jury won't just hear about the original allegations, they could also hear evidence about behavior that affects credibility and accountability. Suddenly, the defense has a much tougher road ahead.
Based on his Sunday night, I'm pretty sure there'll be a new case coming.
Yeah.
No, I would ask you.
And we've already talked before about the fact that everything that's happening, a jury is going to know about all that. You understand that? Okay, and do you think that's going to help you or hurt you when a jury hears how you're behaving in the jail? You think so? You think In cause number 241500, you're charged with obstruction or retaliation. Is that a third degree felony, which means if you're found guilty, the range of punishment is between 2 years and up to 10 years. Do you understand? In clause number 24 DCCR 1614, you're charged with aggravated assault with a deadly weapon. And second degree felony offense, which means the punishment range is between 2 years and up to 20 years in prison if you're found guilty. Do you understand that? In cause number 24, DCCR 1615, you're charged with aggravated robbery, which is a first degree felony, which means if you're found guilty, the range of punishment is a minimum 5 years up to life in prison. Do you understand? And then in 250436, you're charged with burglary of the habitation, which is a second degree felony. Punishment range in that is between 2 years and up to 20 years if you're found guilty. Do you understand? I have here on the computer a plea bargain rejection that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 10-year term in prison on a lesser offense of robbery. You have every right to reject that. That's fine. I just want you to know that after today, I will accept no plea agreements. A jury is going to decide, because I don't know that I even agree with this. So today's the day. If you want to take it, fine. If not, you're going to trial. A jury will decide if you're guilty or not. And then if you are found guilty, that jury will determine what your punishment is. And is that what you want to do?
All these charges going to be on one trial?
They don't necessarily have to be, because you've got 3 different days.
Robbery and aggravated assault.
Okay, so what can happen is you will, it sounds like the aggravated assault and the aggravated robbery will be tried together. It's important that you understand also, if you're found guilty on those, then the state can also try you later on one or both of the other. If you're found guilty on those, because the offense dates are different dates, there is the possibility that any sentence that the jury gives you could be stacked or run consecutively. Do you understand? Okay. All right, we'll get a second trial. Go back with bailiff.